You know, when they return to the bench after the holiday, the Supreme Court is going to be considering whether the history of cell phone locations stored by a phone service provider is searchable without a warrant. Now, Fred, this is the case Carpenter versus U.S., and it centers on Timothy Carpenter, who basically says that his Fourth Amendment rights were violated, and that's because the government used cell phone locations without a warrant, but used that data to convict him of a string of robberies in Michigan and Ohio. Your thoughts on this?
I think, you know, there's a reason why I was a prosecutor for years, and all kudos to Richard. I don't do criminal defense work. I think his argument is quite frankly garbage. It's a legal term. He has no expectation of privacy in where he was. I mean, it's the same evidence that they could have gathered from asking people where they thought he may have been if they saw him. Secondly, there's what they call this third-party issue, where he waived his rights to claim privacy in information that gets to his cell phone carrier. So this notion from the ACLU and all these other people, you know how lawyers hate slippery slopes, that from this decision, they're going to be able to get everything from his Google searches to his heart rate to whatever else you can get from your cell phone. I think that argument doesn't hold a lot of water with me, and I don't think the guy has a legitimate Fourth Amendment right here.
Well, Richard, you know, the government says that they're using a 1986 law for this, but they even go further, saying that, you know, that basically he gave up his rights to privacy by signing up for this cell service. What do you think about that?
Well, first of all, as you mentioned, it's a 1986 law before the internet was around, before cell phones were around. This is called the Storage Communication Act of 1986. The Supreme Court, and I disagree with Fred, the Supreme Court has already said that the police need a warrant to search somebody's cell phone after an arrest. So this is just going down the same line. This is why I think they took the case, because I think it's important to weigh in on stuff that has not been contemplated in this Storage Communication Act. So yeah, I think there is a Fourth Amendment violation. You did not waive your expectation of privacy because you signed up for cell phone services. Look, when somebody pulls you over, the police officer still has to ask, can he search your vehicle? And you have to give an intelligent waiver and say no. Here, there's no opportunity for somebody to say, no, I don't want to have my cell phone records checked. You have no opportunity whatsoever. And the standard of proof under this act is much lower. So I think the Supreme Court will find it was a violation of Fourth Amendment.
Well, with new types of technology, there's lots of different ways to collect evidence. We will see where this goes. Richard, Fred, thank you.
Thank you.